Okay, good morning, good afternoon, good evening to everyone. Thank you for joining our session on the role of the expert in the UK and in India. I'm going to quickly introduce the panel before we start our discussion. First of all, my name's David Goodman. I'm a former partner of BlackRock Expert Services. I'm now a managing director at Kroll. I'm a civil engineer and delay expert, and I've been appointed on various disputes as a delay expert on major construction projects across the globe. Next, I'm going to introduce Mark Gordon. Mark is also a managing director at Kroll, and he's the leader internationally of our quantum business. Mark's an internationally recognised quantum expert. He has over 30 years experience in the industry, and he's been appointed over 70 times as a quantum expert, again, across the globe on major projects. And next, Dinesh Pardasani from DSK Legal. Dinesh is enlisted in the Legal Power List 2021 as one of the top 100 lawyers by Forbes India. He's ranked as a litigation star by Construction Benchmark Litigation Asia Pacific. He's ranked as a leading lawyer by Legal Era Leading Lawyers Rankings 2022. He's ranked as a distinguished practitioner by Asia Law and ranked as a recommended lawyer for dispute resolution by Legal 500 Asia Pacific. So great to have Dinesh on board. Next, we've got Lomesh Nidumuri from Cyril, Amarchand and Mangaldas, or CAM as we call it. Lomesh is head of disputes for the practice for South India and is based out of their Bangalore office. He's part of CAM's group that focuses on international arbitration. He's acted as lead counsel in several arbitrations, and he also acts as an arbitrator. Involved in several initiatives to improve the arbitration regime in India, which is one of the subjects we'll be talking about. And he's also a keen academic. Lastly, I'm very pleased to introduce Dhirendra Negi from JSA. He's been a partner since 2002. He's also been in the dispute market for almost 30 years, and his focus is on commercial and construction arbitrations. Dhirendra has almost 20 years experience, or over 20 years experience, sorry, in handling arbitrations and construction disputes in highways, hydro, thermal, urban infrastructure, rail and metro projects, as well as oil and gas. So I think we've got a superb panel of guests that we're going to be talking to about really the role of the expert. Myself and Mark will give our perception of the expert from a UK background. We're then going to talk about how experts are perceived internationally, and then we're going to move on to how we think experts are perceived and the development of the expert market in India. So I think to start with, I'm just going to hand over to Mark and just ask Mark to give a brief introduction as to the role of the expert, what we actually bring to the table in a construction dispute. So if I could hand to you, Mark.
Thanks, David, and welcome everyone. An expert, as probably everyone who's listening knows, is appointed to assist the tribunal or the court upon a complex technical matter, which is beyond the sort of everyday knowledge. In doing that, there's sort of two cornerstones to the role of the expert. Number one, you must assist the tribunal, and number two, you must be impartial. Now, notwithstanding the natural tension that arises from the fact that the expert is paid by one of those parties, they nevertheless need to overcome that and comply with these two cornerstones of their appointment. And in doing that, they must obviously be sufficiently expertise to answer the questions being asked. They must review all the facts and do a thorough analysis of the evidence. They must be able to provide clear and concise reports and analyze the evidence. They should clearly state the documents rely upon and any assumptions. They should openly engage in the expert process and attempt to narrow the issues. Be prepared to change their mind if persuaded by the opposing party, and obviously answer any questions openly and honestly under cross-examination. there's a lot of other requirements go with this, but I think they're the two cornerstones, and they're the general obligations that fit beneath that. David.
Thanks, Mark. And I'd just add, I think, as I said, myself and Mark have been experts for over 20 years, and that really is the cornerstone of how we undertake our work. And from a UK perspective, there's lots of case law, there's lots of judgments, and what you do find is judges will write, when they write their judgments, they give a little extract about how they found the factual witnesses, and also how they found the experts to be, whether they found them to be helpful, etc. And that for us is very important, because that is the guide of how we should undertake our role. And I was just going to hand it over to the floor and maybe start with Dinesh and just ask, do you see that as, is there anything you'd like to add from your point of view as seeing the role of the expert and how you feel the role of the expert is utilised?
Thank you, David, and good afternoon to all of you. I think you and Mark have put very well the role of an expert, but from my perspective as a lawyer, considering these construction disputes are quite complex and are quite voluminous, I think the experts bring in their expertise to bring out the analysis, which I think lawyers and the clients will not be able to bring with that professionalism and with that expertise. And therefore, experts' role become very important to present in a manner that satisfies arbitral tribunal or a court, so that they get confidence in what client or lawyers are saying. So I think it's a very critical role that experts play, whether it is technical, or it is delay or disruption, or it is quantum. So I think role cannot be undermined, and I think you have put it rightly. Nothing much to add from my side.
Okay, excellent. And I was just going to ask the same question to Lomesh, whether he, his common view of the role of the expert.
Yeah, thanks so much, David and Mark. And I agree with what Dinesh has said. Since we're talking about the role of an expert, I mean, I also did some analysis on this, and I realized that coming from the Indian jurisdiction, a lot of the role of an expert is actually was scripted way back in 3rd century BC itself. There is a famous, a teacher, come philosopher, come academic called Chanakya, who wrote the Arthashastra, and he gave certain guidelines to the king on how he needs to govern the kingdom, and also certain kind of guidelines on how an expert can be brought into adjudication of certain disputes, which I thought was very fascinating. And there, Mark and David, if I may add, the role of an expert was largely to do with the duty to the king or the judge to who the evidence was being given. And I think that notion over a period of time has kind of watered down. In fact, we studied some of the Privy Council judgments just prior to India got independence, some 1940 judgments, where some of the Privy Council judgments have held that experts should not be brought into disputes, because it's the judge's role to actually look into the law of the land and to also appreciate evidence and then come up with their judgments. Because at that particular point of time, on religious matters, you would get some a prophet, or you would get some priest coming and giving evidence on matters which involved religious practices, and certain other evidences as well, which was frowned upon by the era before 1947, which the court said it's the court's job to do it. And of course, through post-1947, we've had several statutes in India itself which permitted expert evidence. But then I think the role of an expert, to be very honest with you, if I can just categorize it into two heads, one is a domestic arbitration and international arbitration. And domestic arbitration also, the slightly large complex disputes and the not so complex disputes. In the not so complex domestic disputes, we do not see experts being appointed that often, because I think there is a certain misconception on the role of an expert itself. There's a certain misconception on who is an expert in the first place, and should an expert be brought in the first place. Secondly, insofar as the large-scale domestic arbitrations are concerned, we are seeing that, but we are seeing that only on a limited scale. But largely, insofar as international arbitrations and slightly more complex arbitrations, we are seeing the trend of a lot of experts coming in, But then again, the role vis-a-vis the arbitral tribunal versus whether they're appointed by the party and therefore they're a hired gun, I think that is something that's still work in progress and a lot needs to be achieved in this regard. I'll just stop here and get the others' views as well.
Thank you, Lomesh. That was very interesting. I'll just hand over to Dhirendra just to add his view, if you've got anything to add to what we perceive the role of the expert to be.
Thank you, David. I'll be very brief. Firstly, I agree with what all the panelists have said just now. There is no doubt about it. But just to add one point to what Mark said, the role of the expert is, in my view, critical to assist the tribunal or the court. So here I'm talking mostly from the perspective of the tribunal. We must understand, we means all the stakeholders, be it the lawyers, the arbitrators, or the clients, that there are a variety of businesses now. There are probably millions of businesses. Now, a lawyer or an arbitrator cannot be expected to know everything about each kind of business, right? So disputes occur in various situations, in various kind of businesses, business transactions, and there has to be somebody to inform, to educate, and to tell the people, the lawyers, the arbitrators, what are the nuances, what are the technicalities, what are the issues which concern a commercial transaction in that particular business, be it a construction dispute, be it a commodities supply dispute, but there has to be somebody, and that's where the expert steps in, and that's where he imparts his knowledge, his experience, his expertise, so that the tribunal can take an informed view of that particular issue which is there before the tribunal. So that's why I have no doubt the role of the expert is very critical. And I mean, probably I'll add it later. So far as India is concerned, we are gradually, but to a good extent now accepting the role of the experts and their evidences in our arbitrations. So I think it's a good change, and I welcome that.
Excellent. Thank you, everyone, for your thoughts on that point. I was just going to move on to looking more internationally and speaking for myself and Mark, and I know Mark will add to it, but we work on lots of disputes across the globe, and we see the perception of an expert varies depending on the jurisdiction you're in, and also, as I said, our overarching role is really to the tribunal. Our job is to make complex issues clearer and also help the tribunal resolve the dispute. And we take that obviously very seriously. And I was talking to Mark earlier, and we were talking about our international experience. I've recently had a case in South Africa where the other side's expert was employed by the company that he was representing, and he did not see that as a conflict. He'd been employed by the company for 20 plus years, and then was representing them as an independent expert. And we found that very hard to take. And but he was questioned on it, and he couldn't see why that was a problem. And maybe that's because, as I said, we've developed our understanding over many years, and maybe that it just hasn't filtered through to possibly to other jurisdictions. And I wondered if Mark wanted to add on just on internationally, what are you finding when we think of the role of the expert?
Yes, David. I mean, internationally, it's quite variable, as you rightly say, David. You've had an experience in South Africa. I've got an experience at the moment in the Middle East on a major international airport. It involves some quite complex technical arguments. And quite interestingly, the client has had to go to the industry and find the best in class experts. So they found 3 or 4 experts who are the top of their game and world-class designers, engineers of airports, but never been an expert before. And it's similar with emerging economies where you haven't got an industry where you've got regular trained experts. You don't want to be an expert's expert, but at least familiar with the process and how to do it. Then they've really struggled. These people are the best in their game. Their CVs are beyond reproach, but nevertheless, they don't know how to write a report. They don't know how to deal with a joint statement. They don't know how to deal with their opposing experts. They're not familiar with cross-examination. They're not familiar with the rigor that the report will be put through. So it's there's an education there with some disciplines in some markets whereby you haven't got people who have got both the industry experience and the experience of being an expert, which I think is the ideal. You got the experience, but you haven't got the expertise, the expert experience. And I think you need a mixture of the two. I think that's always a challenge with either a discipline that's not a well-trodden path, that's fairly unique in terms of its disputes. You bring someone out of industry, or an emerging market where you haven't got, if you like, a regular marketplace in which that discipline can develop.
Thank you, Mark. And I think I just wondered if I pass to Dhirendra, again, talking of international experience, whether you've identified any issues in arbitration that you've come across where you think actually, the expert is not what you would perceive an expert to be, or positive views.
Mark, I will just take forward from where you left regarding your experience in South Africa. In my experience, sometimes independence can be a subjective topic. What one person may think is independent expert may not be for some other person, right? Because that it also depends upon the person who is going to receive the information from the expert. Like, for example, if there is an arbitrator, see, he's the person, or the tribunal panel, they are the persons who's going to decide whether the expert is an independent or not. And I think there are no preset rules as to who is an independent person. But I have noticed in experience, and it sometimes works in very subtle ways, that the tribunal may not accept a person as an expert. So there, the person, the arbitrators, the decision makers, it also depends upon their background, their nationality, their background, their culture, from where they have studied, etc. All these factors, especially in international commercial arbitrations, I've noticed that does play a role as to their experience of, firstly, their background, and secondly, their experiences in acting as arbitrators, as to how they perceive a person as an independent expert. And it's not a there is no benchmark or a common test. I've noticed that. So there are arbitrators who hold experts contemptuously. Really, they hold an expert as a for no reason at all, just because you're an expert, and the arbitrators thinks, I'm an expert in this field. Who are you to tell me? So so that's what has been my experience, and it's been quite varied. So I don't want to point out to a very particular reason, but I've noticed there's something that you need to be very careful as to before whom you are producing your expert. There's some background needs to be done on that. That's all.
Yeah, that's very good. Dinesh, I'm gonna ask you the same question. Whether you've seen any different views internationally with your work in arbitration, whether you've seen the role of the expert vary?
No, I think I would agree with Dhirendra, because it's a very, just by calling a person an independent expert will not make him independent. Of course, the independent experts do give certificates, and that is for granted that, yes, they are independent. But I think it all depends upon, because independent would mean that, oh, look, I have never met a party, or I have not met the other party. But I think that's not the criteria. The criteria is more whether what you are presenting in your report, what your qualification is, what your experience has been, why you've been brought in an arbitration, how you have presented your report, methodology, whether you are confronting with the tribunal or whether you are there to assist the tribunal. So I think those things will actually determine your independence, your impartiality with which you are coming before the tribunal to assist the tribunal in coming to a conclusion or a determination. I think that's the key to everything. Just by calling it an independence, I think will not give anything, because I would say that, to give an example, even arbitrators give an undertaking under Section 12 of the Indian Arbitration Act that they are independent and impartial, and that is sufficient for them. But I think it's a step more for the experts. By giving an undertaking is not sufficient. They have to still discharge the onus to the arbitral tribunal that what their analysis is based on the documents which I have given it to the other party, arbitral tribunal. So I think those are the parameters. If met, I think the true independence will come. So I've seen largely internationally or even in India, I have not come across this African experience that you had. So far, so good with me.
Excellent, thank you. And I'll finally ask the same question to Lomesh, just your experience internationally and whether you've seen any varying expert requirements.
Yeah, thanks, David. I think in terms of my personal international experience dealing with experts has been slightly different from dealing with the Indian experts. I mean, I'll be very candid about this. I think the reason largely is that the notion of who an expert is very, very different and accepted very differently in India compared to what it is accepted internationally. In India, typically, I mean, the trend is changing, no doubt, but as of now, experts are perceived to be an extension of the party itself. So they're called as a party witness. So they're expected to toe the line of the party itself. And if the deposition goes here and there, then, you know, that's something that the expert is largely thrown under the bus, and the parties are not very happy with it. Whereas internationally, my experience has been that there's a lot more sensitization that, you know, the experts largely owe a duty to the tribunal. And I've found that at least there is a conscious attempt that is being made to adhere to that principle. But having said that, fundamentals of an expert report remains the same, whether it is domestic or internationally. I have seen, with all due respect, expert reports getting demolished in cross-examination simply because the experts have not been able to withstand the cross-examination, like what Mark was also making a point earlier, that it's very, very important for the expert to be really perceived as an expert and to also be able to withstand the trial. I mean, you know, that's baptism by fire, right? So that's where the truth really comes out. And if you're able to sort of hold your ground and hold to the opinion that you have said, while at the same time not kind of mitigating the duty that you have to the tribunal, I think that is the role of a perfect, you know, expert, which fundamentals remain the same whether it is domestic or international.
Yeah, excellent. Thank you, Lomesh. I think that's quite a point you touched on there, is the whole cross-examination of experts, and that you can be, you know, you can be a very good expert and you can have a very strong report, but the test under cross-examination is a different test where, you know, you're felt to be under huge pressure, and whether, and again, I was talking with Mark about this earlier, is cross-examination, you know, what is the purpose of it? If you've written a very good report, it's, you know, it's independent, it's factually correct, and then you have a barrister or a KC basically trying to belittle you. I've had cases where they start with your CV and they start questioning you on the background of your CV and go through projects one by one, and that I don't really see the benefit of that. You know, that's all part of the theatre of cross-examination. And I think Mark had an experience in, I think you were saying in Norway, where they took a slightly different approach, which is quite interesting.
Yeah, there's a few different experiences you pick up along the way. I mean, in Norway, they had a different experience whereby there's no cross-examination as an inquisitorial arbitration rather than an adversarial one. So the parties with their experts sat in front of the arbitrator, and the arbitrator asked his own questions. And therefore, the benefit of that obviously is that questions are very focused as to what the arbitrator wants to ask, and you don't get waylaid by what your opposing counsel or lawyer wants to ask you. You don't get asked about your CV, etc. The challenge with that obviously is that the arbitrator needs to be right up to speed with your report and the issues, because you tend to find the questions aren't very, or certainly my experience was the questions weren't very searching. They're more about understanding your report than challenging it. So you really need a good arbitrator who's right on top of the documents when you get to that stage. I mean, there are other things I think that you sort of pick up that work or help towards the independence of an expert. I mean, for example, you sometimes get experts that are instructed to come together before a report's written, and they need to engage and perhaps produce a joint statement before anything's put in writing by way of a report. And what that does is it avoids people taking positions, because once someone takes a position and signs a report to it, it's harder for them to change their mind because it's gone public and everyone's reliant upon it. So I find from an expert perspective that works well, because you've already narrowed the issues and then you just do a report on the issues that you can't agree. Lawyers perhaps aren't so keen because they're a bit out of control at that point, and clients don't really know what you might be agreeing to in that process. The other thing is really just things like PowerPoint presentations and arbitrations in the hearing itself. You know, an expert might produce a report, and we see this quite regularly, that's really complex and it's difficult to get your head around, and it can hide a multitude of sins. I think it helps if you have a good PowerPoint presentation during the tribunal, during the hearing, perhaps at the start, prior to cross-examination. That helps focus the mind, succinctly summarizes the parties' positions. And then hot tubbing, where both experts are put before the tribunal and ask questions at their will at the end, and it usually engenders a debate between them, and it tends to flush out the merits of the respective argument. So I definitely think there are processes that can be adopted that would help. I mean, nothing's ever perfect, but there are certainly processes out there that could assist in arriving at the right answer and flushing out, if you like, experts who perhaps haven't gone through due process.
Thanks, Mark. I think just to add to that, I've got a recent experience where we were instructed by the tribunal, both sides, experts, to issue a without prejudice version of our reports to start with. We exchanged those, and then you know, you could see where where we were both coming from, and we could help narrow the issues in dispute. And I thought that was a really good process, because otherwise you have an exchange of reports, and straight away there's 101 things to deal with. Some of it's just noise, some of it's unnecessary, and it wastes both time and money, which are both important commodities in arbitration. And the without prejudice was quite a good way of just saying, look, you guys get together, have a look at what you're both thinking, and then finalize your reports once you've seen where the other party's coming from. And I thought that was a very good process. I'd like to see that process occur more.
David, it's a good idea, and I think it's very cost efficient and also saves a lot of time for parties. And I did try doing it in India with the government as a counterparty, and I completely failed because they did not agree to it. So I think that's a challenge sometimes when you're dealing with government, where you can't expect them to be reasonable and understand the objective that will save a lot of time for both parties and also cost as well. So I think it all depends upon matter to matter where you can fly this. I think it's the best way of doing it.
Absolutely. I wondered if Dhirendra, did you have something to add?
I agree with what Dinesh has said concerning from totally seeing it totally from the perspective of Indian arbitrations, domestic arbitrations. I have never seen experts agreeing on anything, right? And sometimes tribunals even don't even care whether there should be, exchanging reports or doing hot tubbing, because it is assumed that if there are two experts, they will never agree. So rest is left to the lawyers and their cross-examination, etc., etc. So the process goes on as usual. So there is no innovation as such in trying to adopt better techniques or better practices.
Just
So,
go ahead. Go ahead, Lomesh.
Yeah, sorry, I just want to make two quick points here, just to take off on what Mark said earlier on hot tubbing of experts. In fact, our Delhi High Court in 2017 in the Micromax judgment, in fact, the judge took an opportunity to actually lay down guidelines on the hot tubbing of experts itself, and actually advised parties and the Delhi High Court to come up with a mechanism by which parties would resort to hot tubbing of experts a lot more, which I think was a very welcome move. That was actually a judgment where there was a settlement. So the judge really had no business to get into all of this. But I think just from a jurisprudential point of view, the judge wanted to put it out there that hot tubbing of experts is something that needs to be done, particularly for patent disputes and other kind of disputes. That's something that that is aspirational, but that's still work in progress. The second thing that I wanted to point out is from the legislative space in our country itself, there is no real guidelines on what a role of an expert should be. And that is something that needs to change. You have the IBA guidelines, which Article 5, which essentially says that what a role of an expert should be, and that the fact that they have to be largely independent and impartial, and they have a duty to the tribunal. In India, in fact, we have the India Arbitration Forum, which has come up with certain guidelines. And perhaps it is one of the most progressive guidelines in which they have actually laid down as to how, when an expert is appointed by a party, the party has to make sure that they have absolutely no role in the making of the report, other than just giving inputs to the expert. And the moment that inputs are given, they literally have to wash their hands off and let the expert frame the report. So I think it's very important to understand all of this from the legislative space and how the developments are taking place as well.
Just one last point on this, David, if you allow me.
Absolutely.
So I think now the tribunals have started imposing cost on the party who has lost, and therefore the cost of lawyers and consultants and experts being imposed on the party who has lost. I think that might have some implication on understanding the importance of doing it together and coming only with the disputed issues before the tribunal. So maybe that cost imposition, which has started implementing in India on a very, I think, good note, positive direction. So I think that might help in people understanding in saving cost of the other side and making it more efficient.
Thank you. I think, Dhirendra had another. Carry on, sorry.
Just to add one practical point to what Dinesh has said. See, most of the time, the arbitrators come to the hearings with a clean slate. In the sense, nobody has any idea what the dispute is about. So to expect a kind of a direction from the tribunal that why don't you parties come together and try to resolve at least whatever you can before you come to us. That kind of direction is, or that kind of guidance from the tribunal is also very difficult to find or to even expect from the tribunal.
Thank you. Just one other side point. When Dhirendra, you were talking about you've never seen experts agree anything. I wondered if anyone had experience of a jointly appointed expert, because you know if there's a dispute and there's both parties, rather than have each party provide their own expert, have you seen it where there is a single expert resolving the dispute or helping to resolve the dispute? I wondered if
only under the orders of the tribunal, not by agreement.
Yeah, absolutely. And I just wondered if that was something that in the future dispute resolution. I've always thought it was a good idea if you have the same, as a delay expert, if you have the same set of facts and the same issues, in reality you should come up with the same answer. But obviously that doesn't often happen. Okay.
I think David, I came across, in fact, in one of my arbitrations, I have filed an application where I have sought directions from the tribunal that they should appoint a common expert to value something, which tribunal was quite inclined. They have kept the application pending. And I think after some evidence goes, they will be appointing one. So it is not that tribunal is not inclined when they see value in it, because even their life is difficult when there are two experts giving their report on the same issue. So I think they're also happy to have one common tribunal appointed expert who can carry out this.
Yeah. Mark, I was going to ask.
Yeah, sorry. I've been appointed by the tribunal before. I think it makes absolute sense, doesn't it, that you have one expert appointment and then the tribunal relies upon that. The challenge for the parties is once they see the report, to the extent they dislike it, they want to understand whether it's legitimate or not. So they end up appointing their own experts to assist with cross-examination and to interrogate the report, because often part of it they don't accept, or on the face of it they don't accept. So what happens in reality is you have two behind in the wings experts just commenting and throwing stones, if you like, on the tribunal appointed expert. Now, the party appointed experts got some more merit, perhaps, because the parties engaged and they actively were involved in the selection process of that independent expert. But still, I think I tend to find that the clients and the legal teams don't prefer that process because it feels out of control. They can't see a draft report, they can't talk with the witnesses, they can't create witness statements around the arguments, etc. You know, a lot of what we do is on the delay and the quantum requires gap filling in the evidence with witness statements, etc. Now, until the parties know what those gaps are, and they usually know it through seeing draft reports, etc., and then they develop witness statements around them, and they fill the gaps by witness evidence to some extent. Then, if you don't see any of that coming, then it does leave a bit of a vacuum, and clients and the legal team tend to not be too keen on that process.
You can blame lawyers to some extent.
Sorry?
You can blame lawyers to some extent.
No, see, no, Dinesh, I'll disagree. It's more than the lawyers, it's the clients who are very apprehensive, because that's a very risky proposition of having a person appointed by a tribunal. Then there are a lot of questions that arises. What if he doesn't like what Mark has pointed out? So there is a lot of apprehension beforehand as to what if those points are not covered? What if he says something like this? So it's a very risky thing, and
exactly.
Usually clients don't want to agree to that.
There are pros and cons to it. Of course, it all depends upon, as lawyers say, facts and circumstances of the case.
Yeah. So it's a kind of long way off before we get to that. I think that point of jointly appointed expert. It's a pipe dream that I kind of that I had that I thought would be one day, but maybe not. I was just going to move on to, we've spoken about kind of myself and Mark's understanding of an expert role from the guidance of English law, and I think the other important point is that cases are written up, as I said, and experts are written about, and it can be career ending in the UK at least, where someone is written up by the judge to be seen as an unhelpful expert, a biased expert, and there have been those cases, and there have been careers that have ended unfortunately that way. I just wondered, going back to India, again, I know we've touched on it, but maybe starting with Lomesh, the perception generally of an expert in India, is it what you'd expect to see internationally, or is it something different, or is it changing?
Thanks, David. I think a large part of your question I've already touched upon earlier in some of my points. But just to give you a practical kind of an insight, around 2014 or 2015, that's when I think there was a lot of interest on expert services in the Indian arbitration space. A lot of firms took interest. We obviously got a lot of pitches. They would make their pitch saying that we could come and depose on your behalf, etc. But you would not believe it. Between 2015 to 2018, most of the experts who we spoke to said that they will give the report, but they will not come and stand the test of trial, which was quite interesting at that time. But I know that a lot of them have changed their model now, because their perception of just giving a report was just to give a report to the party, and the same cannot be used in the arbitral tribunal or in any court of law. In fact, they would put that in one of the qualifications as well. But that, I think, the perception itself has changed since perhaps 2017 or 18, where parties also have realized, and the experts also have realized from their end, that they indeed have to come and depose before the tribunal, because a report that is not tested through trial is not a report at all. I mean, it cannot be relied on under Indian law or under the Evidence Act. The person who's making the report really has to come to the tribunal. So I think that perception, both from the parties and from the experts, has changed over the last few years from what I see. So in all the pitch documents that I see today, one of the first things they say is that they are willing to come and depose before the tribunal. And they talk about their expertise before the various arbitral tribunals where they've come and given evidence. The other point, Sorry,
Lomesh, I was just going to ask, why is that? Why do you think that they did not want to testify against them?
I have no idea, David, but that's exactly what the position was. But I'm glad that the position has changed now. A lot of those expert services have changed their model now, and they have realized that they need to step in and give those reports. Otherwise, a lot of these perceived expert services were only giving reports and really not taking it to the tribunal. So I think that's the mind shift change that has happened. The second point that I want to make is the mindset shift is changing insofar as the parties are concerned, but I think it needs to change to a larger extent. Today, if you look at a lot of the domestic arbitrations, I think experts are perceived to be somebody we should go to as a last resort. And in fact, there's a lot of circumspection to say whether you should go for an expert report or not, because they do not want to upset the deposition that's already on record. You would not want an expert to come and say something different from what your parties have also said. And three, I think a lot of parties believe that they themselves have in-house expertise and they don't require the assistance of experts outside. This, of course, depends on the nature of the industry. Some industries are extremely complex, for instance, the construction industry and certain other industries where it's an obvious choice that you need to get experts. But I think there are a lot of other areas, for instance, certain other areas where the parties may believe that you do not require the services of an expert and you can make do with having some kind of an in-house expert who can come and depose. And they would obviously think about the costs because the costs of an expert is perceived to be exorbitant, and sometimes it's perceived to be something that is not required at all. But as I told you earlier, David, I'm an eternal optimist. I have seen how the arbitration regime has changed in our country, and I've seen how the perception also has changed in our country. And I do believe that if there is competence, if there is knowledge, and if there is credibility of an expert witness, I think the parties are a lot more receptive now to engage the services of an expert. And I do believe that that is going to be the future of arbitrations in our country.
Thanks, Lomesh. Before I pass on, I just want to touch on one point you made, and it's something that we see quite often. It is the late appointment of experts. You know, the statement of claim has already gone in; they've already made their position, and then they decide actually we need to bolster this up with an expert report, and that's kind of my worst nightmare, because you know they've already decided what their case is, and it's very hard to, unless it's very obvious, it's very hard to come in late in the day and try and give that independent view on what's already been said once they've kind of set their marker down. And we do see that. You see it when it's so late in the day, and we always recommend, again, easier said than done, but early engagement with experts. So we can look at what you think your case is, where we think your true position is, and really take it from there. And we try to avoid that phone call when someone, we've heard that the other side are about to serve expert reports. We haven't got an expert. Can you come on board? And that's kind of normally a thanks but no thanks from our point of view. I'll pass on the same to Dhirendra if you wanted to add. Just again, what we've been talking about, the perception of experts in the Indian market.
David, there is a historical perspective to this. The role of the experts in Indian disputes, be it courts or be it in arbitrations. See, earlier means say 30, 40 years back, experts meant experts in criminal trial, mostly. Like your handwriting expert, those expert that you need in the criminal trial. So that was what was perceived to be an expert. And plus, we have one provision in our Evidence Act, Section 45. It lays down like who's an expert. So everything was seen from the perspective of that section, and it is still seen from that perspective to a very large extent as to what is written in that section, Section 45 it is. But over the period of years, as what Lomesh has said, things have started to change. Clients have started to understand that yes, we need somebody external, somebody who's really an expert, not somebody who's in-house, not somebody who's just because he's worked in industry doesn't mean that he has become an expert. The difficulty that I see is that how well they are accepted by the tribunals is the question which is of more importance. Because the clients have grown, the lawyers have grown in their attitude, in their perceptions. But there I feel there's a lot more to be done for making the experts to the people where they are really required, and which are the tribunal members. So I think if that's one aspect where we all need to really work on, and it comes in different shades. You know, this subtle or inherent opposition to an expert, it comes in various ways. It may not be expressed to your face. Yes, I have faced very express opposition by one particular tribunal. When I said in my list of witnesses, when I mentioned there is an expert, quantum expert, he said, I don't believe in this expert. I said, the question is why? Because since you have appointed him, he can't be independent. So don't tell me he's an expert. So I had to literally argue, fight, and give all kind of concessions to bring that report on record. So it's, you know, sometimes it becomes that bad. So
sorry, carry on.
No, I think that it is, as all stakeholders, there's need for more awareness, and awareness in the sense more education as to what value an expert brings on the table. I think that is what is required for so far as the Indian market is concerned. So unless that message goes through and the importance of having an expert, we will still be floundering.
It's an interesting point, Dhirendra. I wonder to what extent you think it might change going forward. You know, India has massive plans for infrastructure growth, etc., which will inevitably lead to foreign investment, international investment on a huge scale. Do you not think, to the extent they will expect international and accepted forms of arbitration process?
Yeah, Mark, there it a lot depends upon what kind of a tribunal you have. See, if it is a tribunal of having both
sure,
Indians as well as foreigners, then it's still fine. Right? If it is entirely a domestic tribunal, there may be difficulties there. Because see, ultimately, arbitrators also realize that it is beyond them. You know, you take a construction delay case of construction. It is so difficult to understand how the delay actually happened, what were the delay events and what were their effects, and how does that translate into cost. It is so difficult to understand.
Of course. Mm.
I was just going to pass it on to Dinesh to really, I think we've moved on to, you know, where do we think this is going? You know, in India, we're as a business, Kroll, we're very keen. We've now developed a team in India. We see the arbitration market changing, as Mark was saying. The infrastructure in the pipeline, so to speak, is huge. So how do you see the market developing maybe over the next 5 to 10 years?
I think I would say 5 and 10 years is the span where there will be radical change. In fact, change has already happened. And examples like Dhirendra mentioned, I think are very few now. The judges are understanding the importance of delay analyst. And they understand that it is not lawyers' job. It is the experts who have to present this. So I have no doubts that like in an international market where quantum and delay or even technical knowledge, you need to bring in experts. I think that has become need of the hour. But of course, I say that it is very important for lawyers to strategize and be more focused that where expertise is required. They cannot be bringing expertise for everything. So I think that is an important task that is put on lawyers to decide. But I have no doubt that it is important. And I think it is also important. I would like to go to the previous question about credibility. I think I would compare experts as lawyers, like when we go and argue in court, and when any judge sees that a lawyer is trying to mislead or is not putting the correct position of law before him, he will carry that and will obviously share it with other judges as well. So your reputation carries faster than you think. You might think that, look, you are trying to mislead a court in a courtroom and the other courts will not get to know. That's not the case. They discuss over the lunch table who was a lawyer who was misleading. So I think that carries before the arbitral tribunal also. And the moment, as you say, that the credibility goes down, believe me, that these arbitrators also discuss these issues between themselves. So I think credibility is very important. And I'm sure organizations like Kroll and other international experts who are coming in India are wary of this, and they do bring that credibility, which we all respect. So I think I see a lot of potential for the experts in India.
I fully agree with what Dinesh has said. There is a tremendous potential for experts in India. Because you see the number of arbitrations that we have here, just the volume of them. Even if you are able to catch a fraction of that market, that will still be huge. But the only thing is, like I said earlier, sensitizing people about it, making them aware, and then the acceptability. Then, like Dinesh has hinted at something, experts should also walk the talk, right? Being independent, being, because if there is one expert who has tried to, be smart in an arbitration proceeding and played around with the arbitrator, then the arbitrator then says, oh, these experts are like this only. So he loses faith in
the process.
In the process.
Yeah.
So there is some responsibility lies with the experts also, so that they carry the independence, the most important thing.
Absolutely, and that's what we live by. But in any industry, you always, there's always a rotten egg that that kind of tries to taint it for everyone else. But we live by that. And as I said, I've seen careers ended on that basis. And as Dinesh was saying, everyone talks. Even though arbitration is a private process, everyone talks because that's what happens, and you hear all sorts of stories. But I was going to hand over to Lomesh we've got a few minutes left. So Lomesh, if you wanted to give your view on where you think we're heading.
I think India is poised to, even in terms of economy, it's poised to be the third largest economy in the next 5 years. These are all studies done by international organizations. The economy is expected to increase to more than $5 trillion in the next 5 years or so. So there is obviously a lot of traction that's happening in the Indian market. India is perceived to have handled inflation a lot better than a lot of countries in Europe and perhaps even the US as well. The way they handle the supply chain and how they've kept the inflation low. So there's a lot of positivity around India, and which is precisely the reason why we are speaking here on this forum today. Right, because there's a lot of enthusiasm and hope with the Indian market, and I do believe that great things are in store insofar as the Indian market is concerned, and also the role of experts. But at the same time, I do believe that as I told you, it's always the fundamentals that are very, very important. It's always important that an expert who comes in is perceived as an expert, because I have seen cross examinations where on the first day the witness said XYZ. And on the second day, he said ABC. Then we went back to our strategy room and we decided on the third day, we decided to confront the witness and say, look, you said ABC the first day and then XYZ the next day. What is your exact answer? You will not believe it. One witness took 1 hour to answer that particular question because the witness was clearly caught out. And that is where I think, knowledge of the report, your credibility, and that really comes in handy. And of course, your independence. I think if these fundamentals are set right insofar as an expert is concerned, things are going to be bright. And the last point, as I told you, and just to touch upon what Dhirendra also mentioned, is this whole, the perception game and also the knowledge of, that needs to be disseminated to the parties. There's a lot of, we have the India Arbitration Forum, which is basically a bunch of arbitration practitioners who've come together to change and improve the arbitration landscape in the country. And I can tell you there are a lot of like-minded arbitration practitioners in the country who mean well for the betterment of the arbitration community itself and the arbitration legislation. So we do petition, the government where it is required. We hold seminars where it is required, and to whatever small extent, we do help change the perception that the councils themselves may have about the role of experts, for instance, and also what the parties may have. So I think this is an ongoing process. We are still, I would say, still at a nascent stage. We are definitely better than what we were in 2015 for sure. It's an ongoing process, but as I told you, it's a wonderful future that we have going forward.
Excellent. I think we almost time to wrap up. So, Mark, do you have any last words on? I know that we're both very keen to develop the Kroll offering in India and bring what we think our skills are as independent experts. So I wondered if you wanted to add anything.
Well, just really picking up on what Lomesh was rightly pointing out, that the challenges of an expert who doesn't really understand his duties, it's important that they be adequately trained. But I think there's a short-term sort of feeling that they've got to support their client, and that's a sort of fundamental misconception, because a poor expert would lead to significant wasted costs. It will mean that the legal team may change their strategy if they knew what the truth was. There'll be business uncertainty to the client, and occasionally that can lead to a risk to the business in principle, and I've seen businesses go under as a consequence of an unexpected decision or change or realization of what the truth is. So I think it's an education thing as well. And I think perhaps, I'm sure, the legal team can help in that, in educating the experts as to what the role is and what's expected of them. But it's an exciting future ahead.
Excellent. And I think just my final point is that we, as Mark said, we take the role very seriously, because normally there are millions of dollars at stake, and you have to get to the truth, because otherwise there's lots of wasted time and lots of wasted money and people's careers and everything. So it really is, we do take it very seriously. Dhirendra, yes, I think we've got about 2 minutes left, so if you wanted to quickly.
I just want to add one thing. It'll also make the job of lawyers quite easy if we have experts like you. So a lawyer doesn't then would need to go through those thousands and thousands of pages of documents to crystallize the issues, and instead, whereas a person with your expertise could finish the job in a few days or maybe a couple of days. So the amount of time and cost it saves for the client also would be, there lies the value for everybody. And for the operators to understand the issue and to come to a decision on that issue, it also helps them. So
I think we're all on the same page. Dinesh, did you want to have any last words?
I think all positive, good discussion with you. I think all I would say, considering Kroll has already set up the office in India, which is half the job accomplished. I think what I would expect, and I have faced some problems, is that in Indian context, the contractors are not too professional in maintaining documents. There are projects which get completed where even baseline schedule has not been submitted. So I think the experts have to be flexible enough to accept the Indian records and provide delay analysis. And of course, fees is always an issue. And I understand your perspective also, client perspective also. So I think some sort of hybrid model where you take Indian consultants also along with foreign consultant, provide a more of a hybrid and a more cost-efficient structure. That's all.
Yeah, I think that, Lomesh, that leaves you with the very last word.
I don't have much to add now. So I just believe that the future is excellent, and the attitude of the arbitration community is also going to change over a period of time. It's only a question of time that they realize, as what Mark said, that experts are largely there with a duty that they owe to the tribunal and not really the client.
Yeah, excellent. And I think that brings us. We finished on time, so there's no delay, so there's no dispute. So thank you all for joining. I found that really, really interesting. I hope the people that tuned in also found it interesting. And as we've all agreed, I think the future of arbitration in India is exciting, and I look forward to seeing you all soon.
Thank you so
Thank you,
much,
David.
Thank you.
Thanks, everyone.
Thank you.
Thank you.